everyone. Thank you so much for joining us today. So today's seminar is a joint event co-organized by Chinese University of Hong Kong Faculty of Law, CHK Law, and the Singapore International Dispute Resolution Academy, or SIDRA. So my name is Yuying. I am assistant professor from CUHK Law. So I will be serving as the moderator for today's session. And our colleague from our partner institution, the two speakers, will be presenting some very interesting findings upon a very comprehensive and deep empirical study on international dispute resolution. So we are going to invite our speakers to present for around 35 minutes or 40 minutes. And then we reserve around 10 minutes for Q&A. So for our participants, if you have any questions on today's topic or on this presentation, please feel free to send your questions in the chat. And I will pass these questions to our speakers, and the speakers will address these questions in the Q&A session after the presentation. So before I hand over to our speakers, please allow me to have a very brief introduction of these two speakers. Of course, you can find more information online. So we are very happy to have Ms. Angela Abala, the first speaker, and Ms. Zhang Yuying, the second speaker. So Angela is the research and development lead at SIDRA, and she's also an adjunct teaching mentor at Singapore Management University, SMU Yampang House School of Law. As an experienced dispute resolution trainer, Angela has worked with practitioners and government officials globally. Angela has published extensively in leading journals addressing topics like investor-state mediation, third-party funding in mediation, and arbitrability and public policy issues in the Philippines. Angela is also an accredited mediator at Singapore International Mediation Institute. She also serves as an assistant editor for the Southeast Asia at the Clover Arbitration blog. She previously worked as an associate solicitor at the Philippine Office of the Solicitor General, as well as a judicial fellow for the Honorable Charles Brower. The second speaker is Ms. Zhang Yuying, who is a research associate at SIDRA. She is now involving as an important member of the research team involved in a recent law reform project on Singapore's International Arbitration Act, namely Singapore's IAA, which is commissioned by the Singapore Minister of Law in light of the IAA's 30th anniversary. Yuying has also published in the reputable journals like the Journal of International Arbitration. With her background in mediation, Yuying has trained foreign lawyers and governmental officials in capacity building workshops in countries such as Brunei, Vietnam, and Samoa. She also teaches in Singapore Management University, SMU Yampang House School of Law on mediation and arbitration in her capacity as an adjunct teaching mentor. So without further ado, let's invite our speakers to do the presentation. Please, Angela and Yuying.
Thanks so much, Yuming. Let me just share my screen in a moment. Good. Okay, great. Thank you again, Yuming. I appreciate your time, and I appreciate everybody's time. Thank you for joining us this afternoon. But before we move on with the presentation, let me just share a little bit more of who SIDRA is and what we do. Yuming has already mentioned that, she's mentioned the Singapore Management University Yongpong House School of Law a number of times. We are based at the School of Law there. We are also a platform for thought leadership in international dispute resolution theory, practice, and policy. And so we work on three main research programs, which is the the alternative dispute resolution strand. We also have the international mediation and the Singapore Convention on Mediation strand. And finally, we also work on next generation dispute resolution research programs. But for this particular afternoon, we are focusing on appropriate dispute resolution, and with a focus on our empirical research. As Yuming mentioned, we will be sharing with you all today findings from our most recent report regarding international dispute resolution. And so let's begin with this particular question. How can we improve cross-border dispute resolution? This is one of the things that we tried to look at when we did our empirical research. How can we better help individuals and companies resolve disputes? And so to answer this question, we all need to look at the evidence, right? We can draw from two types of experience. One, which is anecdotal and qualitative, what we hear from practitioners. Like many of you today, I know you are cross-border dispute resolution practitioners here. What we also hear from businesses and individuals who actually navigate these disputes. The other thing that we looked at when we sought to answer this question was scientifically collected data that provides structured insights into trends and best practices. In which case, today we will be drawing on both, but primarily on findings of the SIDRA survey reports, which have tracked international dispute resolution trends from 2019 until now. So this is just the brief structure of what we'll be talking about today. We'll talk about the key features of the SIDRA survey, and then what triggers dispute resolution mechanism with the focus on cross-border commercial arbitration and cross-border commercial mediation. We will compare arbitration and mediation, and should we have time, we'll share other dispute resolution trends that the SIDRA survey has covered as well. So let's begin. What is the SIDRA survey? What is it? What did we try to study? What did we find out? Who did we talk to find out about trends in international dispute resolution? So there are 5 things actually that makes the SIDRA survey unique. The first is it's 100% user-centric. All respondents are individuals with first-hand experience in cross-border dispute resolution. This means that the survey does not capture the views of neutrals, academics, or institutional providers. This is purely the perspective of those who actively engage in dispute resolution. So respondents are, for example, we have a survey on arbitration, and only individuals who have actual experience, you can see that as actually one of the other key feature of the SIDRA survey, who has actual user experience in arbitration, for example, or actual user experience in mediation, only those individuals can respond to the SIDRA survey. So if you're a pure academic, your views are not represented by the survey. But if you're an academic but also still handles cases, your views are also here in this survey as well and represented. The third thing here is that there is a focus on cross-border disputes. There's actually an exclusive focus on cross-border disputes and not domestic dispute resolution. The fourth feature is that the survey was distributed in all 6 official UN languages. And finally, no dispute resolution mechanism was ever examined in isolation. This is because today's dispute resolution landscape is very much interconnected. The rise of hybrid mechanisms such as arbitration, mediation, arbitration, or international court referrals, for example, there's international commercial courts here in Singapore or in London, show how interconnected cross-border disputes have become. And so we've tried to capture all these trends in the survey and did not look at specific dispute resolution mechanisms in silos, but saw them in an interconnected way. The survey is split into 7 sections, which you can see on this screen. These are 7 separate surveys under the main umbrella of our work. We have one on arbitration, mediation, and litigation, again, all international commercial, as well as mixed mode, hybrid dispute resolution. I mentioned earlier ARB-Med-ARB, or there's also a push now to do litigation, mediation, litigation, so Lit-Med-Lit. We also have findings for investor-state dispute resolution, where private investors set up a case with governments directly regarding foreign investment. And last year, in this report, in this 2024 report, we launched two new surveys, which is the intellectual property disputes and tech dispute surveys, which we worked on in collaboration with the Intellectual Property Office of Singapore. So yes, there's 7 sections of the SIDRA survey, but for this session today, as I mentioned earlier, we're only focusing on the first two, which is the commercial arbitration and the commercial mediation surveys. So let me tell you more about the actual 2024 survey. How many responses and how did we track the data? So we collated responses from January to December 2023, so 1 full year. And the respondent profile, we categorized them into 2. The first one is client users, defined as corporate executives and in-house counsels. And the second one is external counsels, who are dispute resolution lawyers and corporate lawyers who also work on disputes. We have 211 respondents across 26 countries, including Singapore, the Philippines, and Hong Kong. And our corporate executives and in-house counsels, they work on industries such as trade and distribution, the telecommunications industry, health, finance, construction and engineering, and even the travel industry as well. So knowing all that, we now dive into the data. So we'll be showing in the next few slides, we'll be showing charts and graphs. We also have actually an interactive portion where we'll ask you to pull out your phones and scan a QR code or click on a link and participate on some quizzes that we have in order to better understand the findings of the SIDRA survey on arbitration and mediation. So first things first, the question that we want to look at is what triggers dispute resolution mechanisms? We often focus on factors like efficiency, cost, and enforcement of dispute resolution. And these are for sure undoubtedly very important. But there's another key question. What actually drives people to cross-border dispute resolution in the first place? And so we asked this question for obviously arbitration and mediation. What we found in arbitration that most respondents choose arbitration because they are contractually obligated to do so. So you can see that in your screen. It's the 90% over here. And it's the yellow line because that's representing all respondents. Contractual obligation meaning, as we may all know in this room, is that they already have a dispute resolution clause that specifically says you must arbitrate this dispute. Apart from that, another trigger is external counsel's advice at 48%, and finally, client's request at 38%. So this is for arbitration. Let's remember the top 3 factors here, triggers rather. It's contractual obligation, advice, and client's request. For mediation, it's fairly similar. But the first one here is external counsel's advice. It's the lawyer suggesting that commercial parties in a cross-border dispute try mediating so that they can find a settlement and resolve their issues. And then coming in second here is contractual obligation. So they have a dispute resolution clause that says you must mediate this cross-border dispute. And finally, at 33%, you have clients now actually requesting for a mediation to resolve their dispute. So if you noticed earlier with arbitration and now mediation, the key triggers for both, right, often come down to 3 main factors, which is contractual obligation, client request, and external counsel advice. This emphasizes just how critical the role of everybody in this room is, of how the role of the law and legal professions is critical in the dispute resolution process. Whether it's lawyers advising on mediation or drafting robust dispute resolution clauses that say arbitrate or say mediate or litigate this dispute, the legal framework and the professionals who help shape it, we all play a pivotal role in determining the success of a process. And so this brings us to the point where, an important policy point, where the legal framework is fundamental to resolving cross-border disputes, right? You can have a top-of-the-line legal framework, say, a Rolls-Royce, a Rolls-Royce system, but without the right without the right infrastructure or access, or what the driveway for your Rolls-Royce is, it's like the luxury car not being able to get on the road, let alone the highway. We have these triggers, and you have the right mechanisms and access points. that must be in place to ensure that the legal framework can operate smoothly and effectively to be able to arbitrate and mediate cross-border disputes. So how can we find out what to do to be able to have the right mechanisms and access points with respect to this legal framework that we have for arbitration and mediation? My colleague Yuying will talk more about using dispute resolution mechanisms and what can we do to have the right access points for our dispute resolution framework, such as arbitration and mediation.
Yeah, thank you, Angela. So now let's look at using dispute resolution mechanisms. So right now we have a little activity for all of you, and we're going to show a slide on the screen right now. So we're going to have a QR code that you can scan to join the Slido to answer the questions. And we'll also have the links in the chat box as well. So if you can just click on the first link, which will then show a word cloud. Yeah. Thank you, Angela. So based on this Slido, the question is, so based on your own experience as a lawyer, as an external counsel, what kind of factors do you look for when choosing a dispute resolution mechanism? So say, for example, if your client is looking to resolve the matter quickly, do you use arbitration, mediation, or litigation? Or if they are conscious about costs, then do you advise them to use mediation? So if you're also looking for enforcement, then perhaps in some instances, arbitration might be better as well. So just I will give you guys a few seconds just to write down what kind of factors you're looking out for when choosing a dispute resolution mechanism. Yes, so on the word cloud, I see factors like confidentiality, cost and time, and as well as other factors like enforcement, familiarity, fast, efficiency, comprehensiveness, easy, friendly to use. Yeah, time, mediation, low cost. I also see mediation quite big as a big factor in the word cloud. So that's very interesting as well. Yeah. So now that you've written down what kind of factors you're looking out for based on your own experience, let's look at what the respondents to the SIDRA survey have said. So we asked users of international commercial arbitration, mediation, about the key factors influencing their choice of dispute resolution and whether they were satisfied with those factors. So the next question that we have is what kind of factors? Sorry, let me just pull up the slide. So what kind of factors do you think that the respondents to the SIDRA survey find important when choosing a dispute resolution mechanism? So if you can just click on the second link and just choose what do you think the respondents said were the most important when choosing a dispute resolution mechanism. So I'll just give you a few seconds to choose the factors that you think are the most important. So I see cost is going up, speed and impartiality is also going up, and finality is not as important. So that's very interesting. So if we could just have the right answers shown to the audience. Yes. So the top two factors is cost and speed. So across the three surveys that we've done, usually cost and speed are the top two factors that respondents find.
Oh, sorry about that.
Oh, you go, that's the biggest gap. Yeah. So usually that's the top two factors that respondents find to be the most important when choosing a dispute resolution mechanism. So they look at cost, they look at speed because they want to quickly resolve their disputes. And we also ask respondents, so which factor has the biggest gap between importance and satisfaction? So if you click on the third link, that's where the question will be at. Yeah. So we see that cost and impartiality is also going up. And usually across the three surveys that we've done, we find that cost and speed they also do have the biggest gap between importance and satisfaction. So for example, in arbitration, a lot of the lawyers that we've spoken to, they said that cost and speed are no longer as they're no longer as satisfied with these two factors compared in the past. So right now, a lot of lawyers have said that the cost and speed of arbitration has gone up. So it's now very expensive and it takes very long to resolve a dispute through arbitration. So as compared to like mediation, where the cost is not as much and you can resolve the dispute much faster compared to arbitration or going to court. So now that we've looked at the factors in choosing dispute resolution mechanisms, we can then look at the comparison of the factors in the specific dispute resolution mechanism itself. So looking at arbitration, you can see on the screen here, we have done a graph where we compare the satisfaction and the satisfaction and importance of the factors in arbitration. So as you can see, specifically in arbitration, the top 3 factors contributing to the respondent's choice to use arbitration are confidentiality, direct enforceability, and finality. And these 3 factors are also quite high in satisfaction. And if you look to the left of the screen, you can see that cost and speed are high importance, but very low in satisfaction. And this is similar to the last 2 surveys that we've done. So now looking at mediation, if you look at the screen, you can see that we also have done a graph for mediation. So comparatively, if you look at cost and speed, it's high in importance and high in satisfaction. So this is also consistent with the experience of lawyers that we've spoken to. So they're generally happier with the cost and speed in mediation. And one interesting point that we wanted to highlight is the point about specialist dispute resolution professionals. It's not as high in importance as in arbitration and also lower in satisfaction. Because in mediation, generally you are not looking at the legal issues and the technical aspects of the disputes with the same degree of scrutiny in arbitration. So parties may not really need this kind of experts. So it's not as high in importance as compared in arbitration. So other important factors that we've realized across the last 2 editions include indirect costs to clients' business, preservation of business relationship, and confidentiality. So now I'll pass on the time to Angela, who will then look at arbitration in detail.
Okay, great. Thanks, Yuying, and thank you all for participating in our short Slido activity. We appreciate your input. So knowing what are the factors that parties look at when what's important to them and how satisfied they are with those factors with arbitration and mediation, as you put it, in the word cloud earlier, right? It's cost, speed. Let's zero in now on specific factors, specific issues that are in arbitration. And the first thing that we wanted to share with you all was that we asked respondents what are the important factors that they think of when they choose an arbitration seat and whether they are satisfied with their chosen arbitration seat. So what matters most to them when they choose the seat of arbitration for their disputes? And, across different versions of the SIDRA survey, enforceability of award, you can see here it's at 94%. And the domestic law governing international arbitration also at 94%. Consistently rank as the top 2 factors for arbitration users. 94% of them thought that these factors are important or absolutely crucial, which means that this actually underscores the critical role that the seat of arbitration plays as it determines the applicable legal framework and the procedures for annulment of arbitral awards. But are they satisfied with their chosen seats? Generally, the data suggests yes. So if you look at the right-hand side of your screen now, that's the satisfaction with their chosen arbitration seat, rather. In terms of enforceability, 84% of respondents said yes, that they were satisfied, and 80% said yes, they were also satisfied with the domestic law governing international arbitration. And so these numbers, they're fairly close to each other, 94 and 94 on the importance, 84 and 80 on the satisfaction, indicates that overall, arbitration users find that the legal frameworks at their chosen arbitration seats are functioning well, and they're happy with that generally. Apart from that, we asked respondents about arbitration institutions. Similarly, how do you choose your institution? What matters most when they choose their institution? And you can also find that on the left-hand side of your screen again. We talked about earlier cost, speed, stuff like that. That plays into arbitration institutions as well. The enforceability of arbitral awards, you can have here, efficiency as one of the top important factors at 93%. Respondents want an efficient arbitral institution. They want an institution that has good quality of services in administering proceedings. That's at 92%. It's over at the bottom here. And the importance of institutional rules at 90% as well. So these are the top 3 factors that respondents look at: efficiency, quality of services in administering proceedings, as well as their rules when choosing an arbitral institution. But are users satisfied with their chosen institutions? The data suggests general satisfaction, particularly with institutional rules, which is at 79%, quality of services at 74%, size and expertise of their arbitrators at 71%, and finally, efficiency at 70%. I do note that, respondents think efficiency, 93% of respondents think that it's important, but only 70% are satisfied. So there's this gap between importance and satisfaction, which is why a lot of arbitral institutions still work hard to make sure that their services are up to par, they're efficient, and disputing parties are happy to come to their arbitral institutions. A key development actually in international arbitration this year is that the Singapore International Arbitration Center, or the SIAC, they have new arbitration rules. The SIAC, the 2025 rules, actually took effect on the 1st of January. And I've spoken here about, efficiency, institutional rules, and quality of services. The SIAC sought to update their rules to modernize and streamline arbitration, making the process more efficient, transparent, and business-friendly, which are critical factors for parties navigating cross-border disputes. Yuying mentioned earlier, the preservation of business relationships, efficiency, speed, and cost. So these are things that the SIAC looked at when they changed their rules for arbitration. Some notable changes of the rules include streamlined procedures, expanded powers for emergency arbitrators. Emergency arbitrators under the SIAC rules can now issue protective preliminary orders. And new arbitral tribunals now have the power to make preliminary determinations. That is, they can decide on a particular issue at one point during the proceedings. And this complements SIAC's early dismissal procedure. And this is in the hopes that they can increase their efficiency and quality of services moving forward. We also asked about venue, as we may all know that the institution and venue and the seat rather are different things in arbitration. The top considerations for venue include the quality of virtual hearing facilities, and the quality of in-person hearing facilities and availability of additional services. These are at 89% and 88%, so very close to each other. In terms of satisfaction, they're also generally satisfied with the quality of virtual hearings, 79%, and same thing with the quality of in-person hearing facilities for venues. This data highlights how user preferences continue to evolve, and now, particular with the growing emphasis on virtual hearing capabilities of arbitration venues. Another question that we asked respondents is, what matters to them when choosing an arbitrator? And all 4 of these are just some of the factors that the respondents said were important when they pick their decision maker, when they pick their arbitrators: efficiency, good ethics, dispute resolution experience, and industry knowledge. But I'd like to share that out of all these 4, there is the top 2 factors. Actually, they share the same percentage. Respondents find that when selecting arbitrators, they value good ethics and the dispute resolution experience of a potential arbitrator. Specifically, dispute resolution experience, you can find here, it's at 98%. Good ethics, as I mentioned, it's the same number. It's also at 98%. They also want arbitrators who are efficient, who are able to move the process along efficiently. That's at 95%. And then that's only when the industry/issue-specific knowledge comes in at 94%. Still a pretty high percentage. For example, you have an intellectual property dispute, and so you want an arbitrator who has specific IP knowledge to be one of the people that sits on your tribunal. So it's still pretty high compared to the other factors. Dispute resolution experience is paramount. So you may not, parties may not choose the best industry/issue-specific arbitrator out there, but they value dispute resolution experience for sure. So we also asked, similarly, are they satisfied with the arbitrators that they chose? The data shows a strong satisfaction level, especially for ethics. So that's 86%, that's the highest here. Dispute resolution experience is at 85. So there's a slight disparity between the importance and satisfaction levels. Language ability, which is also at 85, and industry or slash issue specific knowledge at 83%. One thing that I thought was interesting from this slide was actually this portion, that the arbitrator is from a third-party country. So 64% said that's important when choosing an arbitrator. What do you mean by third-party country? Where, you have parties, you have disputing parties, from example, Singapore and Hong Kong, and you want an arbitrator coming from a different jurisdiction, not from Singapore and Hong Kong. And that's what we mean by third-party country during when we did this survey. And we have 62% who were satisfied with that specific factor. This data, I think, we think reinforces that while users prioritize expertise and ethics, there is room to explore whether having an arbitrator come from a third-party country plays a greater role in shaping perceptions of neutrality and fairness in arbitration. So that's an interesting point here that we might want to delve into more. And so similarly, so knowing that that's how you choose, how respondents chose their arbitrators and whether or not they were satisfied with their chosen arbitrators, we also asked about diversity. How diverse is the pool of arbitrators today? And diversity actually remains a key concern for arbitration users. And when asked what aspects of diversity they would like to see more of, they identified the nationality as a top factor here. That's at 73% for all respondents. Ethnicity at 72%, age at 63%, and gender at 62%. This actually marks a shift from the previous iteration of the SIDRA survey, which was released in 2022, where gender diversity was the top concern, followed by nationality. What does this tell us? So while gender diversity remains important, there is now a growing emphasis on geographical representation and cultural perspectives in arbitration. I mentioned earlier, arbitrators from a third-party country. Users are looking for a broader, more inclusive range of decision makers, one that reflects the diversity of the global disputes that they handle. I do note that there are a lot of efforts these days in the recent years to improve diversity in arbitration, with efforts focused on ensuring more inclusive representation in the selection of arbitrators. In fact, the Hong Kong International Arbitration Center, or the HKIAC, updated its rules just last year in 2024, and it now includes a new provision aimed at promoting diversity. Article 9A of the new HKIAC rules encourages parties and co-arbitrators to look into diversity when designating arbitrators. In fact, the HKIAC is required to take diversity into account along other relevant factors. Of course, we don't want diversity for diversity's sake when appointing arbitrators. So these changes continue to underscore the HKIAC's commitment to fostering inclusive representation in international arbitration. And just very quickly, we also asked users, what technology do they find useful? Has technology in arbitration become a lasting transformation or just a temporary fix? We do note that the virtual online hearing here, 90% of the respondents found it useful. The previous survey, the SIDRA surveys, which were done in 2020 and 2022, were done during the early phases of the pandemic. And then we observed a rapid increase in technology adoption. Now, it seems that the legal industry is eager to retain the benefits of technology rather than revert to pre-pandemic norms. There's also now strong support. So you have here dedicated ODR platforms of 72%, which offer integrated video, audio, text, case management, and document storage, basically a one-stop shop for online dispute resolution. This suggests a growing demand for this type of solution for parties. And the data underscores that technology is no longer just a pandemic necessity, it's an integral part of the future of arbitration. Similarly, we asked what would respondents, what would make them choose a wholly online platform, make their arbitration completely online. And most of them, all respondents, said travel restrictions would make them push for online arbitration, for a complete online arbitration, which again is not surprising. And so, as I said earlier, technology is now one of the reasons that online arbitration is now a useful tool that parties also may benefit from and use in order to resolve their disputes via arbitration. We also had a very quick question on the survey about third-party funding, where you have a financial arrangement with outside parties to fund your particular dispute, and found that only 21% have used third-party funding, and 72 understand how it works but have not used it. This might be because there are jurisdictions that are still not that where third-party funding is still not allowed. My home jurisdiction of the Philippines, for example, third-party funding is not something that's currently allowed, but there is a move to amend the 21-year-old Alternative Dispute Resolution Act of the Philippines. And one of the things that the proponents are pushing for is to legalize third-party funding. So these numbers should change in the near future. Let me now pass the time again back to Yuying.
Yeah, so now looking at mediation in more detail, so one of the first items on the checklist that parties and counsel think about when commencing mediation is venue. So they want something that's accessible, something that's neutral and unbiased. So people might then turn to venues such as their lawyers' offices or mediation institutions or hearing centers. And these are also the top few factors in the SIDRA survey 2024. And you can see respondents choosing these few venues as their top choices. So when choosing mediation institutions, what are the factors that respondents look out for when choosing a particular mediation institution? So if you look at the screen, the top few factors of importance when it comes to choosing mediation institutions are efficiency and cultural familiarity of the panel of mediators, and also the quality of services administering these mediation proceedings. And if you look at the right side, looking at satisfaction with the choice of mediation institution, you can see that the satisfaction with efficiency is high, but cultural familiarity and quality of services is low at 75%. So looking at cultural familiarity, institutions do generally try to have a diverse panel of mediators. So for example, the Center for Effective Dispute Resolution has a global panel that consists of mediators from over 40 countries and have different language skills. And as for quality of services, there are jurisdictions where they are more stringent in training their mediators, and also for the services of the institutions as well. So one example that we have is Austria, which is a civil law jurisdiction. So their accreditation workshop is regulated by the Civil Law Mediation Act and the EU Mediation Law. So this workshop actually lasts over 365 hours, which is split into theory and practice sessions. And this particular workshop also delves into personality theories and psychosocial issues, as well as requiring the participants to shadow in the field of mediation. And another example that we have is the Singapore International Mediation Institute. So they have a post-mediation feedback system where mediation parties and their representatives are given feedback forms, and this helps the mediator to obtain feedback on how to improve after each mediation. So another issue that we ask the respondents is on selecting mediators. So looking at the slide, you can see that there are a few factors that you can think about. What do these respondents think are the most important when it comes to selecting mediators? Is it cultural familiarity, good ethics, dispute resolution experience, or industry knowledge? So when we ask respondents about these, the top two factors are actually good ethics and dispute resolution experience. And these are the same for selecting arbitrators. And generally, respondents are satisfied with these factors, as you can see from the graph on the screen. So if you look at other factors, such as a mediator from third-party country and formal qualifications, these factors are not as important when it comes to choosing a mediator, but more respondents are actually satisfied with it. And this is the same for the previous editions of our survey. So looking at choosing mediators from third-party countries, for arbitration, you generally want someone from a third-party country so that they don't favor a certain party, or they have the impression that they do favor a certain party. And the parties want someone to apply the law in a fair and objective manner. But for mediation, it's different because parties might want someone who understands the nuances in the culture, which will then be more helpful in facilitating the settlement. And this can help the parties reach a more comprehensive solution. And as for formal qualifications, these are not as important as well because anyone can mediate. The skills required for an effective mediation do not lie solely on paper qualifications, but it also depends on their rich and diverse experience in the relevant field. And this will then help the mediator identify underlying interests and concerns that the parties themselves may not be aware of and help the parties arrive at a more beneficial outcome. But even though formal qualifications are not as important, there are many institutions that still have stringent standards to ensure the competency of mediators. So one example is the Australian National Mediation Standards, and these standards addresses matters such as power issues, impartiality and ethics, competence and interprofessional relations. And the mediators under these standards are also required to participate in continuing professional development training. And they also address areas where the mediators should maintain their competencies in, such as knowing how to handle the dynamics of power and violence, communication patterns in conflict, and negotiation situations, and also cross-cultural issues in mediation. So looking at the diversity in mediators, there are a few factors that we ask the respondents about. So when it comes to improving diversity, we ask them about ethnicity, gender, age, nationality, and the type of legal system background. And so when we ask the respondents, there are actually 81% of respondents that said that the limited diversity in the choice of mediators have impacted their satisfaction with the outcome of the mediated settlement agreement. And 73% wanted to see more diversity in ethnicity, but only 45% wanted to see more diversity in a type of legal system. And this reflects the fact that because mediation is a less legalistic process and more flexible when it comes to arbitration, the type of legal system doesn't matter as much. So looking at using technology in mediation, we asked the respondents, what kind of technology do you find useful when conducting mediation hearings? So the most useful factor that the respondents have found is communication platforms for virtual hearings, such as Zoom or Skype or Microsoft Teams. So this is also the top factor for our 2022 survey. But in our 2020 survey, only 35% have found it useful. And this is not surprising because the 2020 survey was conducted before the pandemic. So during the pandemic and post-pandemic, this particular factor has risen a lot in the usefulness that the respondents have found. So if you look at other factors, AI tools such as negotiation support tools, predictive analytical tools, and analytics for the appointment of mediator, this factor has been gaining popularity over the years, but respondents continue to find them limited in their usefulness. So other tools such as the negotiation support tools might be useful for disputes that are of a lower sum or less complex, such as straightforward consumer disputes on online shopping platforms, but may not be able to fully capture the nature of disputes that have a higher sum or are more complex. So looking at the next slide, when would respondents use technology? So the top factors that we have from the respondents are lower costs, followed by travel restrictions. And this is similar to our previous editions of the survey, where we also have travel restrictions and lower cost as our top few factors. And looking at third-party funding in mediation, 8% of our respondents have used it and 79% understand how it works but have not used it. And actually 50% of our respondents have used it for enforcement proceedings. So generally, respondents are aware of third-party funding in mediation, but very few have used it. And third-party funding is largely unregulated in the UK and Australia, but in Singapore and Hong Kong, there has been regulations in place. So for example, for Singapore, since 2021, the legislation has permitted third-party funding for mediation related to domestic arbitration proceedings, court proceedings arising from or connected to the Singapore International Commercial Court for as long as those proceedings remain in the SICC, and appeal proceedings arising from any decision made in the proceedings commenced in the SICC. So with that, I've concluded the section on mediation. And we're now going to look at a few of the dispute resolution trends that we have found to be quite interesting from the SIDRA survey. So for enforceability in mediation, we wanted to ask you, have you been more satisfied with enforceability in mediation over the years? And that is what we also asked the respondents over our 3 editions, and the answer is yes. Over the years, respondents are becoming more and more satisfied with the enforceability. So in 2020, the respondent satisfaction was at 55%, and in 2022, it was at 56%, and now it is at 71%. So it's possible that the Singapore Convention on Mediation has contributed to this increase in satisfaction. And it could also be that the practice of enforcing these mediated settlement agreements has been gaining traction. So more people are aware of this avenue to enforce the obligations in the mediated settlement agreements. And now looking at investor-state disputes, I'll hand the time over to Angela.
Sure. Yuying earlier mentioned, so we also have a mini survey on investor-state disputes, and Yuying has said that there's now an increasing satisfaction with enforceability of cross-border mediated settlement agreements. We see also now in the space of ISDS, there is a growing demand for the ability to use mediation in investor-state dispute settlement, which is interesting because primarily it's been arbitration. More and more people, 74%, would like to see more mediation in ISDS. Institutions have taken note of this, such as the International Center for the Settlement of Investment Disputes, or ICSID. They now have their mediation rules for investor-state disputes. And Yuying earlier mentioned that the Singapore Convention probably has now played a part in the increased satisfaction and enforceability. We also think that as more and more people know about the Singapore Convention, and the more and more people know that the Singapore Convention can also apply to investor-state disputes, these might also bake into why more people want to use mediation in investor-state disputes. With that, we are actually closing ending our presentation. We are hoping that at the beginning of what Yuying and I shared with you today, we wanted to answer how can businesses improve. How can we improve dispute resolution mechanisms, and how can we help individuals and businesses engage in cross-border commercial disputes? We've shared with you factors, what's important to businesses and individuals, what they're satisfied with, what's not important, and what they have low satisfaction with. And hopefully knowing these factors backed up by empirical data can help us create better policy decisions and create decisions also for our clients, finding that, looking at mediation and arbitration, we are able to look at these factors and determine what's the appropriate dispute resolution mechanism for our clients and for specific cases. And I think we are on our last slide. We are actually, sorry, before I forget, and before I hand the time back over to Yuming, SIDRA is actually running the 4th iteration of the SIDRA survey. We're doing this for the 4th time. This survey is running from January until the end of this year. And we have a QR code here, and we'd like to invite you, professionals in this Zoom room with experience in cross-border dispute resolution, whether, as we mentioned, whether or not arbitration, mediation, litigation, hybrid mechanisms, there's a long list. When you scan this QR code, you'll get to a landing page where you can click on what dispute mechanism you've experienced with. If you only have experience with arbitration, please feel free to click the arbitration survey and answer and respond to that. If you are also a corporate executive in this room, in-house counsel, please feel free to also answer. We'd appreciate your input. Each mini survey, if you're doing just arbitration, if you're doing just mediation, it takes around 15 to 20 minutes of your time. It's completely anonymous, and your responses will help shape a publicly available report that highlights global trends in international dispute resolution. All these reports, all these versions are available on our website, sidra.smu.edu.sg. And we hope that you can join us in shaping the future of dispute resolution, as we truly value your insights and hope you consider participating in this important study. Thank you so much, and we appreciate your time.
Thank you.
Thank you very much. Thank you, Angela, and thank you, Yuying, for sharing with us these very important, findings. And also, I'm very happy to see that we have a live, interaction with our participants on, how they are going to choose, what kind of factors they take into consideration in deciding the dispute resolution mechanism. I also encourage all of our participants, if you have the relevant experience, please to help us do this survey. Then we can, collectively and together to shape the future of the dispute resolution mechanism. So now we have around 10 minutes for the Q&A. I already collected a few questions, so I'm going to first post the first bunch of questions to Yuying and Angela, and for you to consider. So the first question is about the the clarification. The first type of the question is about clarifications of this survey. So as you mentioned that you have shown the charts about the satisfactory with the respondent choice, either on the arbitrators and like mediators or arbitration institutions. One question is that what have you included other elements? I mean, in addition to satisfactory, for instance, do you include options for the respondent to select whether they are very happy and extremely satisfactory about what they've chosen, etc.? So this is the one question about the clarification. And the second question about the clarification is the travel restriction. Because the travel restriction, like before the pandemic, there is a lot of like travel bans and restrictions. So whether there is any new restrictions or new types of travel restrictions after the pandemic when you are including in this survey. So this is the first type of questions.
Yeah, so just to briefly address the first question on the spectrum of satisfaction, we do have that in the survey. So we ask respondents, are you extremely satisfied? Are you somewhat satisfied? Or are you neither satisfied? We do ask the respondents about this, and we reflect that in the results of the survey. And if you look at our survey in detail, we do have that in the graphs as well. So this is just what we have on the screen is just a combination of the satisfaction that we have from the respondents. Yeah. And to address the second question as to the different kinds of travel restriction, in our questions, we do not specify what kind of travel restrictions that the respondents might face. So during the pandemic and post-pandemic, the most common travel restriction is because of COVID, because of the pandemic. And during post-pandemic, if there are other kinds of restrictions, it is also included in the factor as well. But we do not differentiate between the different kinds of travel restrictions. Yeah. Hope that answers your question.
Yeah, thank you. And second type of question is about the findings over the past years, because you mentioned that there are some consistencies, especially like the satisfactory of the cause and the speed, impartiality, etc. So the question is, why is this consistent? Why do you see this consistency? I mean, we have been talking about this resolution mechanism. We want to improve further. So do you include any questions such as, has the cause or the speed or confidentiality or other elements has been improved over the past year? Is there any similar questions in this survey? And a similar question is that you mentioned that there is a consistency in terms of the response on the online hearing after the pandemic, right? But now it seems that the COVID-19 has, ended globally to some extent. So do you anticipate that you will receive different response in the new survey, such as in 2025?
Yeah. Thanks, Yuying. So let me answer that in two ways. The first one is that why is there consistency? I would say that we failed to mention earlier, the SIDRA survey is conducted every 2 years. So that's why we have a 2020, 2022, and now 2024 report. And in these three editions so far, I would say policy changes don't happen overnight. It also doesn't happen every 2 years. It doesn't happen very quickly. But we do see changes. And I anticipate in the next coming edition of the SIDRA survey that will be reflected. As I mentioned, right, this year you have the new SIAC rules, which is which covers new ways to make your your arbitration efficient and cost effective. So I'm sure like when that's widely used, there will be changes in satisfaction. Maybe more efficient satisfaction and efficiency in arbitration institutions. The HKIAC updated its rules just last year in 2024. So as I said, like policy changes, they don't happen overnight, but changes have been happening, and I'm sure this will affect the future editions of our findings. Regarding the other question was travel. So we don't specifically ask, so now that the COVID pandemic has ended, what do you think? But anecdotally, we follow up with interviews with respondents regarding the SIDRA survey. And a lot of them definitely has said that in terms of online dispute resolution, they're happy to do it, but in certain portions. A lot of the qualitative interviews, follow-up interviews that we've done with respondents, specifically with external counsel, they're not comfortable, for example, doing a cross-examination online. Some still do it. We know a particular practitioner who still has to do it because sometimes it's an issue of cost or the issue of availability of the tribunal and other parties. But he said that if he was given a choice, that he'd rather do the cross-examination in person. So yes, there's issue of online dispute resolution. Before, everything had to be virtual because of the pandemic, but now anecdotally, we've been seeing that users and practitioners are happy to put some of the process online and still continue to put back rather big chunks of the process like a cross-examination in person. So that's something that we've noted and that we've also written about, which you can also find in the SIDRA survey report.
Yeah, thank you. I here have the last two questions, but which are about the mediation. So the question is, how does third-party funding in mediation work? Because how is that different between like third-party funding in mediation, third-party funding in arbitration? And this is first question on mediation. The second one is, do you think the mediation in Singapore is really very effective working so far? And what are the current challenges to do mediation in Singapore or in Hong Kong?
The first one.
Sure, I can take the first one.
Okay.
Yeah. So when it comes to third-party funding in mediation, when we talk to third-party funders, when they choose the cases that they want to fund, there are a few factors that they look at. So they look at the probability of winning, the cost of the dispute itself, etc. And how they choose these cases will then depend on these factors. So when it comes to mediating and arbitrating the disputes, there is not much difference when it comes to selecting cases if they choose to go for arbitration or go for mediation. So there's not much difference when it comes to third-party funding in mediation. Yeah. So Angela, do you have anything to add for that particular point?
Generally similar. Maybe there's differences in how third-party funders are paid. As you know, like you get a settlement agreement, what's the percentage that a funder can get from a settlement agreement? But we've seen also in our research that third-party funding in mediation has been happening, not as widespread as arbitration, but it exists and it's a market now that funders and investors go in. In terms of the second question, the effectivity of mediation in Singapore, yes, actually, there's a lot of institutions here, like the Singapore International Mediation Center, SIMC, and the SMC, the Singapore Mediation Center, where a lot of parties come to mediation. They try it. They're interested. They want to find out. We said earlier, mediation helps preserve business relationships. And I think one thing that's good about what's happening also in Singapore is how the institutions are interconnected. We keep talking about earlier about ARB-Med-ARB. So the Singapore International Arbitration Center, for example, has a protocol with the International Mediation Center so that there's a seamless transition from arbitration to mediation and to arbitration. Similarly, there's also now a Singapore International Commercial Court, and they recently released, I'd like to say last year or the tail end of 2023, a protocol on lit, med, lit, right? So it's really also arbitrators as encouraging parties, telling them that these protocols exist. And people are taking notice. There's more and more people, and there's an uptick of commercial mediation in Singapore. I know that, Yuying, the other part of your question was comparing it into Hong Kong. Unfortunately, I'm not very familiar with the mediation field in Hong Kong at the moment, but I do know that there's also a huge arbitration community in Hong Kong, and that the HKIAC is also moving towards having their own, they're having their own mediation rules and making sure it's updated so that you have options that you can pick from and find out what's appropriate for, as I said earlier, for you, for your clients, and for your particular dispute. Yeah.
Yeah, thank you so much. Thank you very much. If we do not have further questions from the participants, I think that's all about our seminar today. I want to thank Angela Yuying again for the wonderful presentation and the generous sharing with us.